D.K. Basu versus the State of West Bengal. A public interest litigation in the Supreme Court of India. On 26 August 1986, the Executive Chairman of Legal Aid Services, West Bengal, wrote to the Chief Justice highlighting reported custodial deaths and police violence. The letter sought stronger custodial safeguards, police accountability, victim compensation, and PIL status for the matter. Recognizing the seriousness of the issue, the Supreme Court treated it as a writ petition.
The Supreme Court noted rising custodial deaths, issued notices to states and the Law Commission, and sought recommendations within 2 months.
Various states, Union Territory of Chandigarh and the Law Commission of India filed affidavits before the court.
Custodial torture and abuse of police power were recognized as widespread concerns affecting the rule of law. Articles 20 Clause 3 and Articles 21 and 22 were highlighted as protections against unlawful arrest, detention, and coercion. The Supreme Court held that custodial death was one of the worst crimes in a civilized society governed by law. The Supreme Court explained why custodial crimes are difficult to prove because evidence is controlled by police. The Supreme Court issued mandatory requirements applicable in all cases of arrest and detention. The arresting and interrogating police officers must display clear identification, name tags, and designations. The details of all officers involved in the interrogation must be recorded in an official register. The arresting officer must prepare a memo of arrest at the time of arrest. The memo must be witnessed and signed by the arrestee. It must record the date and time of arrest. The arrestee has the right to have a friend or relative informed of the arrest and place of detention promptly, unless that person already witnessed the arrest memo. If the relative lives outside the district or town, the arrest must be communicated through the legal aid organization and the local police station within 8 to 12 hours. The arrestee must be informed immediately of the right to notify a friend or relative of the arrest or detention. The arrest must be recorded in the detention diary. The name of the person informed must be mentioned. The details of the officers having custody must be recorded. The medical examination has to be conducted on request at the time of arrest. All injuries are to be recorded in an inspection memo. The memo must be signed by the arrestee and the arresting officer. A copy of the memo is to be provided to the arrestee. The arrestee must undergo a medical examination every 48 hours during detention. The examination must be conducted by a trained doctor from an approved panel. The panel of doctors should be prepared by the Director of Health Services for all districts and tehsils. Copies of all arrest-related documents, including the memo of arrest, must be sent to the magistrate. These documents are to be maintained as part of the official record. The arrestee may be permitted to meet his lawyer during interrogation, though not throughout the interrogation. A police control room must be established at district and state headquarters. Arrest and custody details must be reported within 12 hours. The information must be publicly displayed. Violation may lead to departmental action and contempt of court proceedings. The Supreme Court held that constitutional courts may award compensation for violation of fundamental rights. The court held that sovereign immunity is not a defense in constitutional remedies for rights violations. Compensation under Articles 32 and 226 is distinct from private law damages. Compensation is an effective remedy for established infringement of the right to life and liberty. The Supreme Court sought to curb custodial violence, protect human dignity, and strengthen accountability.
Thanks for watching.